We want to welcome everyone to the Fourth Circuit Court of Appeals this morning. We have two interesting cases, good lawyers. The first case is Cooper versus Doyle. Mr. Levine, good to have you with us.
Hey, good morning. May it please the court, there are two reasons why this court should reverse the district court's denial of summary judgment to 4 police officers based on qualified immunity. First, the district court made legal errors in its application of the Graham factors and defined clearly established law generally. And secondly, the district court mischaracterized certain facts and relied upon those facts as material when they are not. This court has never denied qualified immunity to police officers who were confronted with a violent convicted felon who was armed with a handgun, who fled from them on foot, pulled the weapon from his waistband, and pointed at them. That has never happened. But that is precisely what the district court here, by relying on facts that are not disputed and are not material, and by misapplying the Graham factors. Court's error with respect to the Graham factors was first to incorrectly determine that the first prong, the severity of the offense, favored the...
Let me ask you this before you, I just want to make sure under the collateral order doctrine that we're all on the same page, that we can only consider, we're only considering the law for purposes today, not the factual findings of the district court.
And we agree with that.
Okay.
And we certainly recognize the court's jurisdictional limitations. We're not asking the court to resolve any disputes of material fact. The issues on appeal are limited to legal errors in applying Graham.
You may have changed some of the facts in your statement there a few minutes ago.
I'm sorry, Your Honor?
You may have changed some of the facts already, or tried to.
Well, and I'll get to the examples, but in denying qualified immunity, the district court relied entirely on one fact that's not disputed. The district court said, well, Mr. Okran, some of the rounds struck him in the back. Our position is that's not material in this case. Of course some of the
It's not material that he was shot in the back?
Not on this record. And the reason is, of course he was shot partially in the back.
He was shot in the back, what, 7 times out of 8?
There were 3 rounds that struck him in the back, but the record is clear. He was fleeing from the officers, and all of the testimony is consistent that he pulls the weapon from his waistband, and Sergeant Delgado describes that high elbow coming out of the waistband.
I think the district court says that testimony is self-serving, and that is what she's saying is the issue of fact for the jury to decide, because there's some inconsistencies between the statements of the officers regarding a flash, hearing a gun, the issue of the shell casings. I mean, so even though we're not doing a factual review here, those are the things that led to her decision regarding it being a genuine issue of fact for the jury to decide.
But none of those are material. For example, the shell casings, I'm not even getting to the firing of the weapon. The officers aren't required to wait until the weapon's fired before they can defend themselves. So even discounting whether the weapon was fired, there were shell casings from the officers that weren't found. There were 27 rounds fired, 4 of the casings were not recovered.
27 rounds fired
by the officers in total.
And 8 that struck him.
And 8 that struck Mr. Okran, and 4 casings that were never recovered, which is not uncommon in a large parking lot that was sort of waterlogged. That isn't unusual.
So can we just set the facts here so that you are arguing the legal issue? It seemed like the district court said repeatedly, there is a dispute of material fact about 2 things, whether he pointed the gun and whether he fired the gun. It said, the plaintiff accepts defendant's version of the facts except for these 2 things, and her opinion finds a material dispute of fact about these 2 things. So you have to accept, and you have to accept that on this appeal, right? Now those may prove to be wrong. It may, the facts may prove otherwise. But right now, we have to accept that he didn't point the gun and he didn't fire it, can you still prevail on qualified immunity at this stage under those facts?
We can, because the only thing the district court relied on in concluding that there's a...
But you said earlier that he did point it and he did fire it.
Our position is the weapon was pointed and fired. There's really nothing...
So
in the
you
record.
dispute the facts that you said
But I'm
earlier.
discounting the firing. So
An
I'm
issue.
setting aside the firing and focusing only on the pointing. And what the district court said was, well, the only way we can call into question whether it was pointed is the shot placement. And that's not a material fact in
Like,
this case.
you've got to accept that, right? She said there's a material fact about pointing and firing. But now there's still, I mean, you've still got a lot of facts to work with here. He's running away. They know he has a firearm. Somehow it gets out of his waistband at some point, right? Because it's found by his right hand. There's the high elbow. There's the reaching. I mean, are you saying on those facts, it is not, it was not clearly established that you cannot prevail on the facts as the district court found them? Or are you saying you can prevail on the facts as the district court found them?
Well, I think it's twofold. I think accepting those facts, that he's running, he blades, turns, and the high elbow comes up, they don't have to wait until the weapon is pointed in their direction. But again, the court does not have to accept the district court's characterization of a particular fact as material. We're not disputing the genuineness of it, which is not, I agree, is not reviewable. But that issue of whether the firearm was pointed because of where 3 of the shots landed, there's no materiality there under this fact pattern, under this record. It would be material, I would concede, if the testimony was that Mr. Ocran ran, stopped, turned, and squared up with the officers. And the testimony was, now he's facing us and we're shooting. But that's not the record. So under this fact pattern, of course there were rounds that struck him in the back. He's running and turns slightly. That is undisputed. And the district court can characterize those statements as self-serving. That's their sworn testimony under oath, and it's completely consistent with all of the physical evidence in the case. So I think it's vastly different than, for example, Nibs or some of these cases where you have essentially a faultless plaintiff who's standing in his living room with a shotgun, and the deputy says, well, he lowers it in my direction. And this court said, well, but the estate has produced competent evidence to dispute that. There was expert testimony in that case that there was a dispute about whether the weapon was pointed up. There's nothing like that here. There is nothing in the record to call really into question at all their testimony. This
But
issue
in
with
Nibs, there was no, the court really surveyed the case law, and in Nibs, there was no threatening movement, right? Or at least there was a dispute about whether there was a threatening movement.
that was the
And
whole dispute.
any sort of furtive movement. The officers saw one, but it was disputed.
Correct.
And that seemed to be the decisive factor from what I can tell.
That was the decisive factor. The deputy claimed the shotgun was lowered in his direction. And again, the estate in that case had expert testimony in the record that based on the forensics, the shotgun was likely pointed towards the ceiling. There's nothing like that in this case. So we have a fleeing convicted felon, and they knew an awful lot about him, and we detail this in the joint appendix beginning at 441. All of these text messages, he's looking to pull robberies, he's not going back to jail, he'll shoot it out. They knew an awful lot about Mr. Ocran before he fled, reached, and the weapon begins to come out. So even if we stop there in the analysis, it is objectively reasonable to use deadly force on a fleeing felon who reaches and begins even to draw the firearm. They don't have to wait until it comes completely out or is pointed in their direction. They're running through an apartment complex parking lot in the dark, and they have a split second to decide if they're going to be shot. And so even if we ended the fact pattern there, and there's no dispute leading up to that moment for sure, and our position as to the pointing is, again, there was nothing else the district, and I...
Do you accept the fact that he didn't point the weapon?
I don't accept the fact that he didn't point the weapon.
Do you accept the fact that he didn't fire the weapon?
I'm discounting whether he fired the weapon.
Do you accept a fact that he did not fire the weapon?
I would concede that
Do you accept that as fact?
no, I don't. I don't. There's the
You're talking yourself out of the jurisdiction of this court.
but the court doesn't need to get there. And I have discounted whether he fired the weapon is not relevant to the reasonable force analysis. They don't have to wait to be fired upon. And so if we stop with the furtive movements in the waistband, the deadly force is authorized at that moment. And again, the court entirely relies on the location of the shots in the back in denying qualified immunity. The court separated its analysis into two parts. The court says, well, there's a dispute about whether the round was fired. I accept that for purposes of the court's jurisdiction. But as to the second issue, whether the firearm was pointed, the only fact the court relied upon was, well, he was shot in the back 3 times. That's not material, given our context. It could be in other cases, but it isn't.
I didn't ask you if they were even material. I asked you if you'd accept those 2 facts, and you won't.
Well,
So you won't, you didn't come up here to talk about the right issues, I don't think.
well, let's assume we accept the fact that the firearm wasn't pointed and the firearm wasn't shot, as Judge Rushing indicated. The furtive movements alone are sufficient, and that's not disputed. The district court didn't mention anything about any dispute of fact regarding whether the weapon was on his person. That's undisputed. It's undisputed he was armed.
That is. I mean, there's no question he was a felon. He was a fleeing felon. He was shot in the back 27 times. He had a weapon. That weapon was not fired.
This court has never.
That's the case, basically.
This court.
And she didn't accept the fact, he didn't point it and he didn't fire it.
And that's fine. And this court has never denied qualified immunity when you have furtive movements like the ones we have here, where you have a.
So you do accept those facts?
I'll accept those facts.
Though, do you accept those
I do
facts?
accept those facts, because we can still move forward on the furtive movements that are undisputed. He's reaching into his waistband, the elbow comes up, and we can end the analysis there.
But the district court, see, is your position that the district court is, that is not a disputed fact? Because my reading here, it seems as if the district court is saying that is a disputed fact. If he turned, if he pointed, those are the things that she's saying that are disputed facts that are for the jury to decide.
I don't think she made any reference to the turning. I think she said that whether the weapon was pointed at them could be called into question, and she relied entirely on the placement of the shots. There's no contradictory evidence in the record at all about turning or how he turned or when he turned. She relied entirely on placement of the shots and denied qualified immunity on that basis alone. I see that my time is up, other than my reserved time. Thank you.
Thank you, sir. Mr. McDaniel.
Good morning, and may it please the court, Brian McDaniel on behalf of the appellees. We've always taken the position that there are genuine issues of material fact that make this case appropriate for a jury's determination. Appellants have gone from we dispute or contend with the district court's finding that there is at least a genuine issue of fact regarding whether or not a shot was fired or whether or not a firearm was pointed, now to conceding that that was at least determined by the district court to be in dispute. But then they turn to this court and say that what is still at issue is, well, actually what is not at issue is whether or not there were these furtive movements which supported a finding that the shooting of Mr. Okron by these defendant officers was reasonable. I contend and submit to this court that even those facts are disputed and should not be the basis for this court's overturning of the district court's ruling. The issue here is that many of the positions that the defendant officers, appellants have taken all throughout their attempt to overturn the original ruling of the court is based upon their determination that what it is that the officers are saying is in fact true, that in fact it is the gospel. And because these officers have taken the position that one, Mr. Okron fired a firearm, two, Mr. Okron pointed a firearm, or three, now that there were these furtive gestures, means that there should not be a trial.
Can I ask you about the clearly established right?
Yes, Your Honor.
The district court found that there was a clearly established right to be free from deadly force when armed, fleeing, and non-threatening. And the case, the only case that the court relied on for that is Henry versus Purnell.
Yes, Your Honor.
Do you agree that Henry versus Purnell was not about an armed suspect? That was the court said repeatedly in that case the officer had no reason to think he was armed.
I agree, Your Honor, but I think Henry stands for the proposition, one, that one should not be shot, the fleeing individual should not be shot in the back by law enforcement, and that the question still remains whether or not in that situation or even in Mr. Okron's scenario, whether or not an officer is aware of the fact that there's this constitutional right to remain free from this type of use of excessive force.
So the clearly established right the court found is inaccurate. It's legal error.
I wouldn't say it's legal error, Your Honor. I would say that it's not necessarily exactly analogous because of the distinction between the facts.
Well, it's not just a question of whether it's analogous to this case. It's even, does that clearly established right exist? And it certainly doesn't based on the one case she cited for the proposition.
Well,
Right.
I think it's a finer point than that, Your Honor. I think the clearly established right is informed by that case and cases like it, where individuals have been shot in the back, and that law enforcement is aware of the constitutional right to remain free from that level of force. I point the court to Risher versus Chapman, which was from 2019, the Westlaw case 926414, where Mr. Risher was shot in the back, and that the court made a determination that there was a clearly established right to be free from that level or that type of excessive force to be used, where Mr. Risher was a driver, the law enforcement officer pulls up behind him, Mr. Risher avoids that officer, eventually gets out of the vehicle, runs, and that there was then this contention between what Mr. Risher said about whether or not he had a firearm, whether or not he actually even pointed the firearm, and what was...
Here there's no dispute that he's armed, right?
I think that the record supports that, yes, Your Honor. But I
Let me
think...
ask you this, but in Henry, there's and I understand that he's unarmed in Henry, but there's much discussion about the threatening in Henry. How is that different than here?
Well, here, the allegation, Your Honor, is that they believe that he represented a threat to the officers and to potentially other individuals, although there's no indication on this record that there were any other individuals out there, by virtue of the fact that he had this firearm and is running. There's no suggestion other than the contention that he turns allegedly and points this firearm that he in any other way represented a danger to anyone else.
But those are issues, I think, that the district court said are issues of fact for the jury to decide.
I agree.
If he turned, even though counsel said that it's not, it's JA 562, where she says that a jury, that is an issue of fact, a jury could decide that he did not turn. So I think what we have before us under under, what we can review is that Mr. Okron is running from the police, I think her question is that the way the district court says is the right, she identifies the right as the right not to be shot in the back while fleeing officers when the officer suspected that the individual was armed, but the individual never pointed a firearm at the officers was clearly established on January the 8th of 2021. And then that's when she cites Henry. And so she cites Henry and she discusses the running away, the fleeing, and then she says, she points out the non-threatening portion of Henry.
Yes, Your Honor, but in this instance, and I thank the court for that clarification, in this instance, I think part of the problem is that the appellants rely heavily upon the assertion that these events took place in the way that they allege they took place. So if we accept that the district court found at least that there's some question about whether there's this firing, pointing, and we would submit to the court that there's even the question about whether or not this furtive movement took place, then what we have is a situation in the light most favorable to the appellee is an individual who was running from police who was shot in the back.
Did the district court find a dispute of material fact? I thought she listed two, like kind of repeatedly, she listed two disputes, genuine disputes of material fact that prevented summary judgment here, and it was pointing a weapon and firing a weapon.
I only raised the furtive movement because now it appears that the appellant is suggesting to the court that this court can rely upon the record which supports from their perspective a finding that he made this furtive movement and that is undisputed.
We just have to accept what the district court found, right? Like it's, and sometimes that's a trick to try to figure out, well, what are the facts that the district court was operating on? But she seemed to say plaintiff accepts all of these facts except pointing the gun, firing the gun, and then she has some paragraphs going through the evidence and finding a dispute about pointing it and firing it.
And I think that's accurate, Your Honor, but what the court did not say is that it's undisputed that there was this furtive movement, which I think is what the appellants now have rose to suggest, that on this record, because the district court did not enumerate that as part of the 2 or 3 issues that are in genuine issues of material fact, that now it's undisputed that there was this furtive movement and that this court can rely upon that in overturning the district court. And
wasn't that part of the sort of set of facts we have to accept, that she didn't find a material dispute about whether there was the high elbow reaching for the waistband, whether the gun was previously concealed but later, exposed?
I would just say to this court that it doesn't appear from the order that she made an affirmative finding that actually took place. But even if the court were to, on this record, suggest that, if the court found those 2 other issues of genuine issues of material fact and that stood on the record, it's our position that that would be insufficient to overturn the district court's ruling, particularly given the other objective evidence that the court and any jury would have in order to place what it is that the officers are saying in terms of what we would submit to this court as our self-serving narratives about what happened. And what are those? That the court has already highlighted the fact that there were some 27 shots that were fired. The appellants suggest that there were 4 shell casings from those 27 shots that were not found. But as it relates to the firearm that they allege Mr. Okron had there and that allegedly was fired, there is no shell casing from that firearm. Also interestingly on that point is the fact that there is the gunshot residue test that is done where gunshot residue is found on the left sleeve and the right sleeve of the coat that Mr. Okron was wearing, but not on his hand, that was preserved from the scene. And then all of this takes place in the context of what the appellee would say, the inappropriate meetings between the officers prior to their formal interview by Detective Hamill in connection with the criminal
And the
case.
judge took that into account in assessing the, I guess, their credibility. But there was no evidence that they had done anything inappropriate at those meetings.
Certainly,
They had talked to each other and socialized, and this case came up. I would think that that's reasonable under the
Yes.
circumstances.
yes, Your Honor. So what was, so the court said,
But they used some of the lingo that was similar to one another, she thought.
right, I mean, the court thought that it was mentionable that in the depositions of each of the officers that talked about the meeting that they had prior to their being interviewed.
And she mentioned that they were the witnesses that were still alive.
These are the only witnesses, unfortunately, for Mr. Okron, who are still alive and able to provide the account of which we would submit to the court is and are self-serving. But I think even larger than that, these officers, particularly a supervising officer, Officer Delgado, who's responsible ostensibly.
But we have to take the facts the way she recited them, right?
That's right, Your Honor. And so I'll not spend too much time on that, but has always been interesting to the appellees that these officers who are aware of the fact.
I think they now say they don't dispute any of the facts that she found.
I think that's right.
Recited.
I think that's right. And so, in short, Your Honor, we believe that the ruling of the district court was appropriate at the stage that we are in, that the appellant's position requires that this court view the evidence in the light most favorable to the moving party as opposed to the non-moving party, and that this court should uphold the ruling of the lower court. And upon that, we would submit.
No more questions.
Anything else? Thank you very much.
Thank you.
Appreciate it. Mr. Levine, you've saved some time.
Thank you, Your Honor. I think that there's a distinction to be drawn between viewing evidence in the light most favorable and engaging in sheer speculation, if not fantasy. This court has never said that you can overcome summary
So
judgment.
you're saying that there's speculation in the rulings of the court? Is that?
Well, I'm just.
Or in the argument today, or what?
Well, we're not going to rehash all of the factual issues because I don't think that's, what we're relying upon.
Don't you raise the term speculation? How's that get in here? What's the?
Well, again, with the location of the shots and that being material fact, it isn't material because the jury would be left to speculate as to the significance of that in this fact pattern. But I want to talk about clearly established because it's raised in our papers, and it is one of the arguments that we've made that the court did commit a legal error with respect to the clearly established prong of the analysis. And again, Henry versus Purnell, a taser case involving an unfortunate set of facts where a deputy thought he was drawing a taser and drew a firearm. That's not what we have here, someone who's non-threatening and fleeing. Again, there is nothing in the district court's opinion that calls into question the furtive movements that are made. And so, again, discounting the pointing of the firearm, discounting the firing of it, and suspending disbelief that any of that actually happened. Just relying on the undisputed facts in the record. And Judge Chasnow didn't point out anything that calls any of this into question. You have an armed, fleeing felon. And again, we can zoom out in light of Barnes and May. We can zoom out and talk about all of the things they knew. This wasn't a case where you have someone who ended up having a cell phone or a beer bottle or some of these other cases where you have essentially an unarmed individual who shot while fleeing. They knew that he had a firearm. That is undisputed. And it is also undisputed that during the course of this foot pursuit, the hand goes into the waistband. And again, we can end the analysis there, where it's coming out. And when Mr. Okren was found, that weapon was not in his waistband. It is undisputed in this record that that weapon was out. It got out somehow, and the officer didn't pull it out. There's nothing in the record to suggest that. So if the court ends its analysis there by taking the facts as the district court found them, there is nothing that would preclude a granting of qualified immunity based on you have 4 veteran officers who see an individual they know for certain is armed, and the hand goes into the waistband and the weapon comes out. This is not one of those cases where there is no reasonable basis to conclude that that posed an immediate threat to their lives. In that split second, we cannot put officers in that position where they have to wait longer than that. This is not a low-level type of offense, and we raised that in our papers as well, that there was a misapplication of the first gram factor. The first gram factor, accepting the facts as the district court found them, does not favor the plaintiff, because the court focused only on this misdemeanor offense of carriage of a weapon without a permit. That's not, and this court made clear in Anderson in 2001, that is not the analysis on the first gram factor. The analysis is, what was the offense at the time that the deadly force was employed? Because if we accepted the district court's analysis, then a shoplifter who pulls a gun and deadly force is employed, we would say, well, the crime was shoplifting. It may have been earlier, but once the gun is involved, and as that gun is coming out, now we have assaultive type behavior. We have an immediate threat to the officers' lives. So there were two significant legal errors that the district court made, in addition to the mischaracterization of certain facts as material when we contend they are not material. And they are, one, the misapplication of the first gram factor with respect to the severity of the offense, and significantly, defining clearly established generally. And the Supreme Court's opinions on this have become a drumbeat. The district courts may not define clearly established generally. It has to be very specific. And the district court respectfully did not do that in this case. And I think the citation to Henry versus Purnell underscores that. So for these reasons, we would
You don't like Henry versus Purnell?
Do I not like it?
Yeah, or you do like it?
Well, I think it's a unfortunate weapons misidentification.
You said it's miscited.
No, I don't think I don't think that's the law that is clearly established that applies in this case. You have a subject in Henry versus Purnell, a low-level offense, fleeing from police.
That's an in-bank ruling of this court.
I'm sorry?
That's an in-bank ruling of this court.
And I think it was decided correctly. I'm not questioning
That's what I was
No, I'm not taking
That's
issue
the
with
reason
the
I'm
decision. I'm not taking issue with the decision. The officer in that case never intended to use deadly force. The officer intended to pull his taser and mistakenly pulled a firearm. So we take no issue with Henry versus Purnell, but that law...
Let me ask you about, I asked him this earlier about Henry versus Purnell. The district court seems to focus on the non-threatening portion of that opinion. How is that different here? I'm assuming their argument is that it was non-threatening. He never turned around. He never pointed the weapon. He was still running at the officers.
So this court would have to decide that it's non-threatening when a fleeing felon reaches into his waistband.
And I'm not sure, you keep saying that the court made a finding that the court said that, but I'm not, that the district court said that wasn't disputed. I'm not sure. That seemed to me a little gray in the opinion. But if you can show it to me, that'll be great, where she says that it's not disputed that he pulled a gun.
I don't think the court said it was undisputed. I think the court sort of lumped it all together and focused only on the pointing. But the court sort of discounts, and she does recite the deposition testimony where Sergeant Delgado says he saw the high elbow, and the other officers all said they saw the reaching. And again, they know this person is armed. This is not a cell phone case. And so...
But I don't know if she ever, in her opinion, said that fact was not disputed.
Did she identify all of the undisputed facts, or did she identify only the disputed facts?
She identified only the disputed facts. And
those disputed facts could be determined by a jury in your favor, and you still get immunity after that.
well, and I don't... And
She says there's material disputed facts, and that there needs to be a trial. So that trials presumably would decide those disputed facts. You could specify, get interrogatories to the jury on those points, and maybe the jury find them in your favor.
The only dispute the district court
That's what jury trials are for.
I understand, Your Honor. I think the only dispute that
The only question here is whether her ruling that there need to be a trial is to be upheld,
and the court to
as I see it.
And the court to get there has to get past the obvious undisputed furtive movements that Mr. Okran makes during this foot pursuit. And the district
See, I know
court
you
can
keep
do-
saying it's undisputed. She even says, if you look at JA 562, here, a reasonable jury could credit the officer's testimony to determine that Mr. Okran pointed his firearm and perhaps also fired a shot at defendant officers. On the other hand, a reasonable jury could conclude, based on the evidence that Mr. Okran was shot in the back while fleeing, that Mr. Okran never turned around to point a gun at defendant officers. So I'm not sure how you're characterizing that these are undisputed facts. When you have the district court saying at JA 562, that there is a question of fact as to whether or not he turned around, which is one of the further movements you said earlier, is that he turned around and that he pointed the gun. And so how is that not disputed?
But that's a third furtive movement. And so the district court doesn't say a jury could reasonably conclude based on, I don't know what, they would have to just simply disbelieve everything because there's no contrary evidence. The jury could reasonably conclude that Mr. Okran didn't reach into his waistband and the arm began to come up. That's not in there. And this court would have to essentially decide that those furtive movements don't count, that they are not sufficient to allow an officer to use deadly force when they know the person is armed and has said, I'm not going back to prison, I'll shoot it out. And that's exactly what Mr. Okran did. Your Honors, thank you very much. I see my time has long expired. We respectfully request that the court reverse the district court's denial of qualified immunity. Thank you.
Thank you, Mr. Levine.
Its investigative work product and its advocacy admitted as substantive evidence of Mahana's guilt. Over Mahana's objections, dozens of intertwined and overlapping exhibits were admitted in this case in violation of the federal rules of evidence. This appeal has selected and presented three of what we see as the most prejudicial abuses of the district court's discretion during the trial. The harmless error review is not a sufficiency of the evidence review. And so the question is not whether the remaining untainted evidence would have been enough, but the question is whether the prejudicial nature of the admitted exhibits could have or may have swayed the jury. It is the government's burden to demonstrate that none of the admitted evidence that was improperly admitted could have impacted a single juror. We do not believe that they can or have met that high burden, we believe that this court
Has the
should.
government admitted there was error in admission of any of those exhibits?
No, Your Honor.
No, so you have to prove they were erroneously admitted. You have to convince us that Judge Cogburn abused his discretion
Yes,
in the admission rulings.
that's correct. And through our opening and
Every one of the rulings challenged is reviewed for abuse of discretion, if I'm correct.
You are, Your Honor.
I think I am, yes.
That's right. And we believe through both our opening brief and our reply brief and a thorough reading of this transcript, there's not much doubt that there were evidentiary errors and abuses of discretion. And what's important to note is that on a number of these evidentiary issues, the district court mid-trial reversed itself, recognizing that what it had already admitted, what had already been published, and what had
Well,
already
that's
been...
commendable.
It is. But what it does, Your Honor, is it recognizes that even midstream, the judge recognized errors in some of his rulings. And what we don't have, as things are changing midstream, are limiting instructions and corrections to what's going on. So the first of the issues that we
Did
saw...
you ask for limiting instructions, were denied?
In some instances, the court gave limiting instructions. In other instances, it was left unstated so as not to highlight the prejudice that was occurring from...
Well,
one
that's
party.
that's an appropriate way to deal with it in the context of what's going on at the trial. That's what judges do.
That's correct, but it doesn't...
And Judge Cogburn has tried a lot of these criminal cases and other kinds of cases, both sitting on the bench and sitting in your capacity.
He has, Your Honor, and if the court, having read the transcript, will pick up that every participant in that courtroom was very familiar with the case, the evidence, rules of evidence, and all of us have tried many cases, both with, against, and in front of Judge Cogburn in the Western District of North Carolina. If you look at the summary exhibits, these were particularly problematic because they essentially were the government's closing argument slides. They did not serve as a surrogate of underlying voluminous records.
Can you tell us which exhibits you're referring to?
Yes, Your Honor. These are, most problematically are 905, 906, 907, and 908. They are also exhibits 900, 916 through 918, and 920. But I'll start with 905.
Do you agree that all of these could have, I mean, these could all have been demonstratives?
I think if
Like the
they-
jury could see them anyway, if, assume they are the government's cherry-picked closing argument slides, like the jury could see them anyway, right?
I think the jury could have seen them as in closing argument. Whether or not they could have been used during trial of 611, we don't believe so. First, because we don't think they were illustrative of the fact witness's testimony. Detective Meskin didn't have knowledge and wasn't testifying of his own knowledge about facts such that these would be 611 illustrations of his testimony. Instead,
But don't we have, I mean, we have precedent saying that if it could be a 611, then it's harmless.
we have precedent saying that if it can be 611 and there is a limiting instruction.
No, we didn't say there was a limiting instruction in that case.
So this court in Simmons has said that to do away with the prejudice,
Well, right, but in the case where we said it's harmless error, we didn't talk about a limiting instruction at all. And if there had to be a limiting instruction, that would seem to say it could never be harmless, right? Because obviously if the court admits it as substantive evidence, it's not giving a limiting instruction, right?
so I'd agree. I don't know that it has to be binary, though. I mean, I think the limiting instruction, the court says you need a limiting instruction because there's a prejudice. Because what we want is the jury to focus on the evidence and not the exhibit as evidence. And what happened here is not only were they told this exhibit is the evidence, but it was an exhibit per each count in the indictment. And it didn't summarize the records.
Well,
It
the rules contemplate summaries in complex cases.
They do. It doesn't have to be a complex case.
The rules of evidence do.
That's right. Rule 1006 would allow a summary of voluminous records.
Voluminous record. yeah.
That's right, Your Honor. And Rule 611 would allow an illustrative aid to help show the inferences of a witness's testimony. But what cannot happen is the government can't create a document that says, for count 2, look at these 30 exhibits, what that this witness said, that this witness
Didn't they have
said.
to take that part off? I mean, didn't they have to take off the count part?
They did, that's right. After it had been admitted, and after it had been published, and after it had been testified to, the
And
court.
we have that, is it Oloyede? I'm not sure how you pronounce it, right? Where this is what happened, right? They said the court found there was an error in admitting it as substantive evidence, but then said it was harmless because it could have been a demonstrative.
I think because in that case it could have been a demonstrative does not mean that it is always harmless. I think the court has to look at how it was used in the trial, the extent of what was done, and whether or not a limiting instruction was given. Because other courts have said the way to cure the prejudice is with a limiting instruction.
So what is the error? I guess we're skipping over the first step here.
Sure, a summary has to be an objective summary of the records. And the error here is that the exhibits were not that. They were selections of some exhibits, they were selections of testimony, they were selection of everything, and they were submitted not as an objective summary of records, but as a highly curated, cherry-picked version of the records.
The government says we took certain exhibits and we compiled those exhibits into this summary. So do you disagree with that?
I don't disagree that it's based off other exhibits, but if you look at
And
905.
it's a complete
It's not an accurate summary.
summary of those other exhibits?
It's not a complete and it's not accurate. It has only pulled out very few pieces of data from those exhibits that they think show Mahana's guilt.
Okay, but a summary is like not telling you everything, right? Otherwise, it wouldn't be summarizing. Are you saying, I found the briefs hard to decipher on this point. Are you saying there are some entries that are left out, like they only included, 3 of the 4 sales that are reflected in this exhibit? Or are you saying, well, for every sale, they included 3 data points, but not all 12 data points that are in the underlying exhibit?
I'm saying both. And if you look at the invoices, and they only selected out certain electronics, and they only selected from thousands and thousands of electronics that this company sold, the very few specific ones that related to their narrative of guilt.
So I had a question about Exhibit 102, which is supposedly one of the exhibits that underlies 900.
Yes.
We don't have 102 in the record on appeal, and it's not available on the docket. So I could not figure out who is right on this point. The government says we included every IMEI that's in 102 is in 900. And then you have this hypothetical chart in your reply saying, here's things that are from 102 that, are you saying they're not in 900? Or are you saying they're mentioned differently?
They're not in 900. So what they did in 900 is they went through the invoices and they didn't pull out all the electronics. They pulled out the cell phones with the IMEIs that were related to this case. And so what I've attempted to do in alternate 900 is go to those exact same, go to the sales invoices or the purchase invoices and pull out all of the electronics that are not these cell phones, that weren't bought over the counter, that didn't come from other wholesalers, that are simply omitted from it. And
So the
there's this-
government, I guess, they say, we pulled out everything that was a foreign sale, that was sold overseas. And that's the limiting part of 102 that you disagree with? You would take everything from 102?
I think you have to make a summary that objectively summarizes all of the records, not just the pieces of the record that support your theory of liability against Mr. Mahana.
So it wasn't an objective summary, you say?
That's correct. It was a highly selective summary, and that it is summarizing other witnesses' trial testimony is even more problematic, because that's not a voluminous record that needs to be summarized. These very clearly were the closing argument slides, because in closing argument, they showed right up again. And so they really had 2 bites at the apple. They got to do their closing argument with a witness on the stand, then they had their slides admitted as substantive evidence, and then they turned around and were able to say, this is the admitted evidence. You may take this piece of paper as fact that these are the things that relate to this specific count. And as to 906, these relate to count 3. And one of the most problematic parts is that they selected this fraud determination, which was something that AT&T...
Sorry, can I follow up on one thing? You
Yes.
said there's testimony that's summarized in these summary exhibits. What is that? I didn't see examples of that in your brief. You just say it.
Sure, at the bottom of it, you'll see the highlighting, and it connects, by highlighting, they connect certain IMEIs or phones to certain trial witnesses who testified that their credit had been compromised.
Yeah, these are the ones that are related to particular witnesses.
And you can't get there without summarizing the testimony of the witness that I had this happen to me. Like, only through the witness do we know that this is Ronald Ruggles' phone, for example. So you couldn't have had the highlighting, and you couldn't have connected anything in that exhibit to the witness without the witness having to testify.
So it's just the highlighting.
And then the statement of who it was, like at the bottom of the exhibits, it said the witness's name. So as to those, the third column said fraud determination. And this was that Verizon had determined that it was first payment fraud or account takeover fraud. And we objected to those being mentioned at all because those were decisions about fraud that had
Didn't the
made.
district court give some limiting instructions
He
kind of
did.
repeatedly about that?
He did, but that's the problem, is that in this exhibit that then gets admitted, one of their 4 columns is fraud determination. And they put it back in front of the jury over and over and over, despite that limiting instruction, and say in their brief to this court, well, we picked that because it's one of the most relevant factors. But the court said it's irrelevant, and jury, you're not to consider it. And so to repeatedly put that through its exhibit and then have that exhibit admitted as substantive evidence, we think is prejudicial. And we do believe that maybe there could have been, in an instance, something could have come in that was a summary exhibit. But we don't think it could have come in through Meskin's testimony. And we think in this case, a limiting instruction was necessary so that they weren't confused and they weren't focusing on what was published and what was submitted. The next issue that we saw as most problematic were these business records of Verizon, AT&T, and T-Mobile Sprint. And in short, what happened here is the government did an investigation. It created a list of cell phones that Mr. Mahana had sold and a list of cell phones that Mr. Mahana had purchased. And it gathered data about those two different, the sales and the purchases. It then sent that list, that spreadsheet, to these cell phone carriers and said, give us information about those phones. Now, had they just given information that was their business records, their data in spreadsheet form, I don't know we'd have an objection. But what they did is they incorporated the government's investigative work product into their spreadsheets. They then sent those spreadsheets.
Who's the they in there?
Verizon, AT&T, and T-Mobile Sprint. And they showed up with.
How did they incorporate it? Is it just that the government asked us about these specific sales and those are the ones that we pulled our data on?
No.
Okay.
So as to.
What other part of the
As to
investigation?
Verizon, the exhibit was never a paper copy. It was an Excel spreadsheet. And it's in the special media volume. If you look at Exhibit 14A, it has multiple sheets. And when you look at the sheets that are in Excel, you see that it is the replication of the government's investigative data. And the AT&T spreadsheets, 27A and B, there's data in those spreadsheets from AT&T about the date Mahana purchased the phones, about the wholesaler that he purchased it from, about the date he sold it, to whom he sold it overseas. And so the government's investigative spreadsheet goes to the carriers and then comes back, and now the carriers are saying this is our business record, but it contains all of the data that they got from the government. Had it just been their records, Judge Rushing, that would be one thing, but they have taken the government's investigative product and sent it back to the government, and now the government tried to admit it as a business record of the company. And that's the problem, is that lurking in all of this was the government's data. I asked the Verizon witness, is column BS, is column BT, is this your data?
So it's just those 2 columns are what you're talking about? Because
No.
weren't those, the district court said you have to cover those up, take those out?
So those are illustrative of the problem, and it's not just those 2. But that's exactly right. He said that's not our data, but that proves the point that this spreadsheet that they sought to admit was not the product of regularly conducted business activity. And so that exhibit was inadmissible on that basis.
But the data in it was.
Some of it was, but what was the exhibit was a hybrid of their data and government investigative data. And because of that hybrid, it was impermissible.
Can you show us where that is? Because I know you referenced some things that were on the spreadsheets that I didn't see. So can you show me where exactly, which spreadsheet I'm referring to?
Yes, Your Honor, and I see my time has expired if I
You
could.
answer questions as long as you get them.
Yes, Your Honor. So in 14A, I believe that there are 3 sheets, and I don't have it right in front of me, but in the Excel document, it should be sheet 1 and sheet 2 and sheet 3 down at the bottom. And in our opening brief, we walk through with specificity how to find those. And one of the sheets is called, I believe, Mahana Sold, and one of the sheets is called Mahana Purchased. And I believe that's in 14A. Or more importantly, 14A also has the far right columns BS and BT. And they were actually highlighted in yellow. And they show the incorporation of the government's data. Additionally, Your Honor, in Exhibits 27A and 27B, they have specific data about the dates that Mahana sold or Mahana purchased specific devices, and there's just no way that AT&T or Verizon had in their business records data from this other company. And so that
Yeah, because like, for example, in 27A, you say that row 2 indicates that on January 8th of 2018, that WCF sold an iPhone with the number, but I can't seem, and maybe it's me, I just can't seem to find it, on row 2. And so, and I don't even see the date that you put in there in your as an example.
and not having the special volume in front of me.
That's fine, yeah.
So we feel confident that data was in there because they were Excel spreadsheets and not paper documents. They existed only in digital form, and they're multi-layers. They're multi-layers of sheets. And so when you look through 27A and B, you see the additional data. And when you look, 27C, for example, is perhaps another one. You have to marry both 27C with the testimony from Mr. Daigle from AT&T. He said that when he was given the list of IMEIs to look out, he then went and did his own research. He went and checked the blacklist. He went and checked Verizon and other companies' records, and he then inputted that data into his system so that his...
I thought he said that was in their system.
It became in their system
He
when
did his
inputted
own
it.
research using the company's business records. It was pulled through our billers, through our database, researched information in our supply chain.
He also went and checked GSMA's blacklist, and I believe it's JA 776 and 777, where he said he went outside their sources to gather information so that it would be complete. And so that to us was, really a business. It got the subpoenas. It went and did investigative work. So the data that it then received, wasn't prepared in the ordinary course of business. And then it turned around and tried to pass that stuff off as its own data. I see my time has expired. I haven't reached what I think might be the most interesting, which is the adoptive business records and the use of unread emails as a statement of the defendant. I'm happy to save that for rebuttal or mention it briefly with the court's permission.
Give you a couple minutes.
Thank you, Your Honor. So the adoptive business records is a theory that the court used to admit a number of exhibits in this case. These were clearly records that had not been prepared by Mr. Mahana. They had not been prepared by any of his companies. There were statements in there that had been made by third parties who were not testifying at the trial, and a number of them were emails sent from one business to Mahana's business. And there was no evidence that Mahana had seen those emails.
Well, now, I think because one of the arguments you've made is exhibits 201 through 219. He certified those.
Yes, Your Honor. Those are, on the spectrum, those are the least objectionable.
All right.
So-
So then that leaves you with 220 through 55.
That's right. Those were the ones that were found for which there was no custodian and no certificate. But I'm talking now about the 300 series. These were the emails from Blowfish and Swift Unlock, and they were advertising emails. They were advertising the services that that company could do. And repeatedly, the objection was made, Your Honor, these are hearsay, and there is no exception for hearsay. And the court said these are business
Well,
records.
business records are.
They went to his company.
The records are hearsay. That's in the rules.
Well, and so then the question is, when you look at the foundation, the elements to have things admitted as a business record, somebody has to come in and lay that
Well, if their
foundation.
business records are hearsay, I mean, that's what
They are, but
but
they're-
they're admissible hearsay.
Yeah, they're an exception to hearsay, they're admissible, but there has to be a foundation laid. And here there was no foundation laid.
Well, if I were to agree with you regarding that, doesn't the government already get the whole, all the evidence in regarding the unlocking of the average, because he gets these emails, he never opens the emails, but there is a relationship between Blowfish, because there's the WhatsApp messages between Mahana and the Blowfish employees. You also have the sums of money between Blowfish and Mahana. And so even if that is an error, how is that not harmless? Because it's already in the record that there was some relationship between Blowfish and Mahana regarding unlocking these cell phones.
The government was using these emails, these particular emails, to say unlocking is itself wrong. It is nefarious, it's a violation of the law. And so by receiving these emails that say, hey, we can unlock a stolen phone, that meant that Mahana was therefore knowingly engaging in the conduct of illegally unlocking phones. What's problematic?
Wasn't there plenty for the jury to infer that from, even without the emails? I mean, they heard that the carriers will unlock them for free, or you can pay, over $100 to have this private service unlock them. Doesn't that let the jury infer that maybe you're up to something if you're paying lots of money for something that would be free if you were doing it legitimately?
What the jury heard was a number of different pieces about unlocking. The government started this case by saying it is a crime, it is wire fraud to unlock these phones. And we moved to dismiss that count, and the district court granted that motion, and count 6 was dismissed from it. We had experts lined up to testify that locking or unlocking the phone was not a violation of law, and it was perfectly permissible. And the court, by striking that count, said, we're not going to get into this, right? I'm not going to weigh in on whether the Digital Millennium Copyright Act or the Unlocking Act makes it problematic or not. Stay out of it. And so that's what we were told to do. And despite that, these exhibits drove right back into, and repeatedly, it seemed to me the government was going back at the idea that unlocking a phone or paying somebody to unlock a phone is itself a violation and is somehow nefarious. And so when AT&T or Verizon comes in and says, yes, we'll unlock it, but if anybody else unlocks it for a price, you should infer that they have bad intent, I think that that's something that could be inferred. But what happened here is they used statements from Blowfish, which were not Mahana's statements, which had never been seen, and they essentially turned it into his confession. Like he didn't adopt these, he didn't act on them. The court even recognized there's no evidence that he ever saw these. And the carriers all said that unlocking a phone is not illegal, right? That evidence, it never came in.
I said I'd give you a couple of minutes.
Yes, Your Honor, and I appreciate the question, because I think this is really important, because what it does
I
is...
know you think it's really important, but I said I'd give you a couple of minutes, and you had about 10.
I do appreciate the courtesy. I will sit down and hear from Ms. Ray.
Think about what you're going to say on rebuttal.
Yes, Your Honor.
Ms. Ray? Good to see you, Ms. Ray.
Thank you, Judge King. May it please the court, Amy Ray for the United States. Your Honors, Judge Cogburn did exactly what we want district judges to do when faced with questions of evidence. Judge Cogburn listened carefully to lots and lots of argument, He considered authority that the parties presented. He is well familiar, as Your Honor noted, he decades spent as both a trial lawyer and a trial judge. He knows these rules, and he made reasonable, fair decisions. The question on appeal is whether any of those decisions were so arbitrary or capricious that they affected Mr. Mahana's right to a fair trial. Was it appropriate? Were they somehow injurious and caused the result to be what it is? And it absolutely not. This case was about the witnesses who testified, not the charts that generated so much of the ink in the transcript, primarily because the parties were disagreeing about whether they should be admitted, but they weren't ultimately that important to the government's case. But even if they had been, the judge made very reasonable decisions, and it certainly wasn't arbitrary or capricious. In terms of the summary charts, I will note that, Exhibit 900. What Exhibit 900 does is it takes the government made the choice to focus on the purchase orders and phones that were shipped overseas because those were most likely to be involved in criminal activity. 1006 does not require that the summary be something other than a summary. And in Exhibit 900, it was very helpful because the jury got to see which exhibit. They could cross-check. The interesting thing about this case, which is different than most cases involving 1006 charts, is every single one of the underlying documents was admitted. So I don't understand how it could be prejudicial, especially when 900 says, hey, if you want to see where this IMEI phone was sold or purchased by the defendant, check out Exhibit 101, 102, et cetera, et cetera. So perfectly appropriate. My friend, Mr. Jones, talks about Exhibits 905 to 908, and he talks about how it connected with witness testimony through highlights. But those highlights were taken off by the district court. The district court required that the government remove the highlights and remove the count 1, count 2, well, it's really count 2 through count 5, I think. They had to take that out. Now, yes, it had already been shown to the jury, as it could have been in closing argument, drawing the connection between this chart and this particular count. But the judge made the right decision ultimately to sanitize that exhibit for purposes of the trial itself and allow the jury, the government to make that connection. In terms of and I'm just going to hit these quickly unless your honors have questions, the spreadsheets by the carriers. Every single one of those carriers testified, the representatives, Mr. Walker, Mr. Daigle, and Getz, that data was exactly the same as what was drawn from their electronic records. There are a number of decisions cited in our brief that talk about how, especially in the day of electronic records, the record is not some piece of paper, right? We can now, I bought a cell phone 2 weeks ago. I never touched a piece of paper. You can sell a house without touching a piece of paper. The data isn't even on a particular computer. It's sitting in some server that could be across the ocean. So what the data is not a piece of paper, it's the record itself. It's the number, it's the date. And so it doesn't matter if you present those in court in a slightly different format. It doesn't even matter, I think, in this case, that the charts included the IMEI numbers that the government had presented, because those were the numbers that one couldn't expect Verizon to show up with every single IMEI that had ever been sold by Verizon.
The defendant claims that there's other information in these spreadsheets, like the dates that he bought and sold them and things that weren't actually the carrier's business records. What's your response to that?
The only ones that I'm aware of, and I will say that I truly couldn't find what Mr. Jones references. So BT and BS on the Verizon, yes, and then those were covered up. So there were 2 columns on Verizon that Verizon explained. The reason, Mr. Walker explained, that the reason those columns existed was actually just to make sure that the device hadn't been returned to Verizon. He wanted to make sure that there were no duplicates. It was actually an effort to be fair to Mr. Mahana.
But these were all business records.
Yes.
That's what I was understanding Mr. Jones said they were not business records.
Well, of course they were business, yes, they were absolutely business records. And I think what Mr. Jones is contesting is that somehow they were not representative business records because they weren't inclusive of every IMEI that ever existed and instead came from the government's. And some, I think he was disputing, Judge Rushing, that on the top of some it said Mana purchased or Mahana sold, but the government explained all of that, and the witnesses explained it, Agent Meskin, that's because those came from that original 900, Exhibit 900 that is, because they ultimately found and chose to include the IMEIs, which related to cell phones that were either bought or sold by Mana overseas. So it kind of adds up to nothing in terms, in my opinion, in terms of both the effect, but also just what's reasonable. I mean, Judge Cogburn really, I think, worked hard in this case to make sure that he made reasonable decisions.
And what was the, like, 3-week trial?
Yeah, it was at least a couple of weeks, Your Honor. I actually meant to look that up before coming up here today so I could tell you exactly how many days. Mr. Jones will undoubtedly recall because he was in that courtroom. But it was a long trial, and Judge Cogburn made...
Was it in Nashville or Charlotte?
It was in Charlotte. Yep, it was in Charlotte. Just to quickly hit the 300 series of exhibits that Mr. Jones talks about, this unlocking emails. Of course, those were a minuscule part of the government's case, those particular emails. But more importantly, as Judge Benjamin, as you sort of referenced, there was a lot of evidence that wasn't related to the disputed exhibits. Perhaps the best one for the government's purposes to show that it would be harmless even if it were error was the evidence of his messages, WhatsApp messages with his brother in UAE. I will reference, for example, Joint Appendix pages 1085 to 86. He screenshots an unlocked, Blowfish Unlocks advertisement that says they can unlock fraudulent phones. And all the evidence about how at one point there was, Mr. Mahana had $11,000 deposited with Blowfish Unlocks. Now, of course, he could have had legitimate reasons for doing that, but there was lots and lots of evidence that he didn't. And also, there was so much evidence about the unlocking feature because it was at least a fair inference that if you're going to pay and have on deck $11,000, there's a reason you're hiring Blowfish Unlocks instead of going to AT&T, Verizon, or Sprint. If your honors don't have any other questions on the evidence, the only thing I do want to make sure I hit is the forfeiture issue.
The cross appeal.
The cross appeal. The rare time when I get to stand up here as an appellant because the district judge just got this wrong. Judge Cogburn, I think, felt, you know, he is a judge who feels for defendants. Not, I think all judges do. And he was concerned about double recovery, which is not something that...
And no one warned him about this, right?
No, right.
It seemed like the defendant thought of this argument in the moment and brought it up, and the government wasn't prepared to say, look, here's a statute in a Fourth Circuit case that says you can't do that.
Absolutely, Judge Rushing. I mean,
Judge Cogburn thought he had discretion,
he did.
and you're saying he doesn't.
He does not. He does not. And I think we've...
But nobody told him.
Nobody told, well, I mean, we did say at sentencing hearing that we didn't think it was excessive fines, et cetera, but it was, I don't know, Judge Rushing, whether Mr. Jones thought of it then, or whether he thought of it ahead of time, but there was no objection ahead of time.
Right.
And there was, and even Mr. Savage, one of our most experienced prosecutors, said, I feel a little sandbagged because he just wasn't expecting that discussion. And it was erroneous, and so the judgment as to the forfeiture needs to go back for the entry of the judgment in a judgment that incorporates the preliminary
Do we
order.
have to specify that part, the specific amount, or can we just remand for entry of forfeiture and leave it to Judge Cogburn to sort out the details?
Probably, although I think actually the Rule 32.2 would require the entry of the preliminary order that he's already entered, because the jury made the special verdict finding and all the rest of it. So I think what would be appropriate would be a remand that says to enter the forfeiture judgment consistent with the preliminary order of forfeiture. That's how I read 32.2. But if your honors read it differently and think it just needs to go back for him to make the determination, that's fine. I think the most important part is it's mandatory. And also, because Mr. Mahana has raised the excessive fines issue to make it very clear that it's not excessive, which would be most inconsistent with this court's precedents, I can, give your honors the cases here that, and I did in the brief as well, but it's not excessive. It doesn't violate any statutory maximum.
It can be challenged under the Constitution.
It could be. I mean, he does.
Yeah, right, so he could have an Eighth Amendment claim.
Absolutely, but that would require a grossly disproportionate
Right.
forfeiture when compared to the gravity of his offense. And what this court has done consistently is say, look, if you're involved in an offense where the proceeds were $1.2 million, forfeiture in that amount is perfectly appropriate. Even if, and in one case, I'm blanking on the name of the case, actually it was Bolin. In that case, the defendant only got $30,000, and this court upheld a $1.2 million forfeiture judgment because the conspiracy itself got 1.2 during his participation in the conspiracy. Your honors, if you don't have any further questions, we would respectfully request that this court affirm Mr. Mahana's convictions and sentence, but vacate the judgment for the entry of a forfeiture judgment consistent with the preliminary order. Thank you, your honors.
Thanks very much, Ms. Ray. Good to have you with us.
Thank you. Always great to be here.
Mr. Jones?
Thank you, Your Honor. So the problem with the summary exhibits is that because they were selective of other exhibits that had already been admitted, by that selection process, they impermissibly bolstered and gave extra weight to certain parts of the data. They pulled out the parts of the data that only reflected the government's theory of the case, and by that selection and by that admission as substantive evidence against Mahana, were improper and prejudicially bolstering. If the court goes back and looks at the special or the media exhibit, it will find in Exhibit 14A multiple sheets. And I'm happy to submit a supplemental 14A, 27AB if they didn't come through in that, but there are multiple sheets in that exhibit which very clearly demonstrate that what was sent in to the jury was not just Verizon's data. It was the government's data and Verizon's data. And it can't be any more clear than when I asked Mr. Walker from Verizon, and this is at Joint Appendix 501 to 504, I showed him the spreadsheets. I said, is this your data? And he said, this is not our data. That is an admission that the thing the government wanted to admit as evidence was a hybrid of Verizon data and the government's investigative data. I agree that the spreadsheet didn't contain everything in the world about every cell phone, nor did it contain every conceivable entry. And I don't have a problem that spreadsheets are an appropriate way to display voluminous data from Verizon. And I agree that not everything is written in paper, but what cannot happen is the government can't send its investigative work product to a carrier or to any business and say, look into this for us. And then that business to send back a hybrid of data that is its own and that is that government work product. And that's what happened here. As to the summary exhibits, 905, 906, 907, please take a look at those again. The government says now the judge did the right thing and there's no prejudice here because those were taken off, but one, too late, and also why? Why were they taken off? Why did Judge Cogburn think that there was something wrong about it saying count 2, count 3, count 4? Because he understood that it meant that they were pulling out for this one substantive exhibit, not a demonstrative, but substantive, the different pieces of trial evidence, not voluminous other records. They were pulling out pieces of trial evidence to highlight for the jury just what they thought was relevant for that specific count as to each of those. And he asked that those be stricken because he understood that that was a problem. As to the length of trial, it was a 5-day trial, and it would have been 4 days, except the government asked that we push it into a 5th day so that it could do its cross-examination of Mr. Mahana at the beginning of the week. So it was not it wasn't a 3-week trial. Yes, there was a lot of ink about these exhibits, but many of these exhibits should not come in. Or had they been presented under proper evidence with a correct custodian, the correct witness, there would not have been an objection. Many of the pieces of evidence that came in were unobjected to because they didn't offend the rules of evidence, but a great many of them did. And so individually and cumulatively, we believe that Mahana was prejudiced.
Do you want to say anything about the forfeiture?
Very briefly. The Supreme Court has said the 8th Amendment is a backstop. And so while I understand there's case law from the circuit that says it's mandatory, the court can't just always do it. When a 8th Amendment claim is raised.
Well, it's mandatory, but if there's discretion about the amount, that seems to be where an 8th Amendment argument could be made, is, well, the amount is excessive somehow. But I didn't see that anywhere in the papers, any like fleshed out argument about why this amount is unconstitutional.
So we said.
And there wasn't a judgment, right? So like there's not even really a forfeiture amount to be arguing about at this point.
That's correct. That's part of the reason why if the court vacates and sends back, it can't specify why. Because the court has to do an analysis of what it thinks is, if it thinks anything is excessive. And if the court has the authority to say that it's excessive, it could look at it and say, I think 1, potentially. Now, it might not withstand scrutiny, but it has the right to do that analysis in the first instance and to analyze the Bajikasian factors and determine, given everything else that's happened in the case, whether or not the entry of a forfeiture is appropriate. And then there are different kinds of forfeiture. And so in this case, there were specific jury findings about specific pieces of property. But then there was also the request for, on top of that specific forfeiture, a money judgment in the amount of $3.6 million. And so the court could determine under an 8th Amendment analysis that only forfeiture of that property is found by the jury is appropriate, but that an additional $3.6 million is inappropriate. The judge in the first instance has to make that, but the judge does get to weigh the factors. And I think it is an open question whether or not, as part of the Bajikasian factors, the court can consider what other payments the defendant is making. Other circuits have said we look at whether or not this fine would permanently deprive a defendant of his future livelihood. We look at it in connection to the loss. And so I think this court could, in its analysis, if it were remanded for that purpose, say, I believe that something less than a $3.6 million money judgment, when I've already saddled him with a $3.6 million restitution judgment, and I've imposed a fine, and I've imposed a special assessment, it gets to alter that number. We do believe that the case should be vacated. I would ask the court to look back at the opening reply briefs, and particularly to look at the spreadsheets and the exhibits. We believe that there is prejudice to Mahana at the trial. As much respect as I have for Judge Cogburn, I do believe that the errors affected this trial, and the case should be vacated and remanded for a new trial.
Mr. Jones, we really appreciate your work, and my papers indicate that you're a court appointed.
Partially.
You mean you were retained for the trial and appointed for the appeal?
I was,
What?
I am appointed in the cross appeal.
You're appointed in the cross appeal.
Yes,
You're partially appointed.
correct.
Well, good thing it gave you a couple minutes to argue about it, sir.
Thank you, Your Honor.
Yeah, you earned your pay.
Thank you.
But we appreciate your work.
Yes, Your Honor.
And